Hello and welcome. I'm Peter Afrasiabi. I'm an intellectual property partner at the law firm of One LLP in Newport Beach, California. In today's program, we're looking at moral rights of artists. We're going to look at Burning Man buses, graffiti art, sculptures of Queen Catherine, living gardens, and even more. And the whole look today is really focusing in on what are moral rights in the intellectual property realm, and what does that mean to our system of intellectual property. Our agenda, as you see here on our first slide, is to look at moral rights in U.S. federal intellectual property law and where they exist for certain artists. We are going to look principally at copyright law and specifically the Visual Artists' Rights Act, known as VARA, which protects certain artistic integrity and attribution rights. And this is going to require us to sort of ask the question, what are moral rights? What does that mean for an artist to have moral rights in his or her work? We are going to look at the scope of those rights as they exist under current U.S. law, and we're going to look at the powerful damages remedies that attach to these rights if they are violated. This allows us in fun case studies to look at the Burning Man Festival, and we're going to look at the famous bus from Burning Man. We're going to look at graffiti art, we're going to look at living parks, at building sculptures, and we're even going to ask the question, what happens to illegal street art when you have various aerosol paintings or graffiti paintings that are done illegally on buildings? Who owns it? Does anyone own it? We're going to ask these questions, and we're going to look at the answers to these questions. So let's get going on our first slide here in terms of looking at U.S. copyright laws and moral rights. And we're going to start by looking at the question of just copyright law before we get to moral rights and sort of the framework that exists before moral rights crept into our federal law, which occurred in 1990. So we need to just set the playing field really to understand copyright law, because moral rights emerge out of copyright law and are a subset of copyright and in terms of the protection for certain artists who create what are copyrighted works. And so let's take a quick overview of copyright law to kind of frame this for you. Copyright protects authors and creators, artists, in terms of giving them certain exclusive rights that are reserved to collectively what we can call them all as authors. And this is the right to control copies being made, the right to create derivative works from the original work, the right to a public performance or a public display of that work. And these are all exclusive rights that belong to the author, and that comes out of our U.S. Code, Title 17, U.S.C. Section 106. And basically, these are utilitarian and economic-based rights that are given to those who create copyrighted works. And infringers can be enjoined or pay damages, and this comes from the same Title 17 Code sections, Section 504, 505. And if an infringement occurs, the infringer can be required to forfeit their profits, pay the actual damages that were suffered by the plaintiff who was infringed, or there is what's known as statutory damages, which allow penalties to be imposed that are distinct from the actual damages or from the profits to serve a punishment, in part a punishment purpose. And these statutory damages can range. It can be, if it's not a willful infringement, it can be from $750 up to $30,000 per work infringed. Or if it is willful, it can go all the way up to $150,000 per infringement. And willful, in most circuits at least, including the Ninth Circuit, for example, is understood to include reckless disregard in terms of behavior. And so we're going to creep into our moral rights perspective by double-clicking now on our last bullet point here on statutory damages, because what statutory damages already do in copyright law is allow for punishment beyond actual profits or losses, and they allow a jury to, in essence, punish and consider other factors. And so here's a quote from the U.S. Supreme Court. It's a 1952 decision, Woolworth versus Contemporary Arts, 334 U.S. 228, from page 233. Even for uninjurious and unprofitable invasions of copyright, the court may, if it deems it just, impose a liability within statutory limits to sanction and vindicate the statutory policy of discouraging infringement. And so in some sense, we can think about statutory damages themselves as already echoing, you could say, moral rights ideas. The idea that when a copyright is infringed and taken, sometimes it's okay to get even more than the pure economic losses in a sort of utilitarian-based model. So now let's ask, what are intellectual property-based moral rights? I mean, when we talk about moral rights, what does this mean? And so you see on our next slide here, moral rights are the ability of authors to control the fate of their works even when the works are sold. And that's a significant concept for us, obviously, as American lawyers involved in property transactions and the like. And it comes from the French droit moral, which is understood to represent rights inherent in the artist's personality. And these rights really transcend contract or property interests. And these rights exist independent of the artist's economic interests in the work. And so at root, the theory of moral rights is that the result that if we give moral rights, it will create a climate of artistic worth, creativity, honor that encourages the creator in this process of active creation so that we can create more art and works for society. And this idea of moral rights found itself in the Berne Convention for the Protection of Literary and Artistic Works of 1886. So it's been in the Berne Convention that many countries subscribe to as far back as 1886. Continental Europe, of course, droit moral from France is where this idea started, but it's sort of a very important concept that's been a part of much of the world's conception of copyright and moral rights for a long time. And here's what the Berne Convention of 1886 says. Independently of the author's economic rights, and even after the transfer of said rights, the author shall have the right to claim authorship of the work and to object to any distortion, mutilation, and or other modification of, or other derogatory action in relation to the said work, which would be prejudicial to his honor or reputation. Now, Berne member states, to which the U.S. had not been a member for a long time, had to meet a minimum level of protection for these moral rights. And it was about a century-long process before the U.S. finally joined the Berne Convention and ultimately modified U.S. federal law to comport with Berne and provide some sort of protection in line with that quote that I have for you there from the Berne Convention. And of course, for us as American lawyers, this may well run against kind of your basic commercial transaction concepts of private property transfers and ownership of property and having free reign over their property. After all, if I buy a car or a blender or a t-shirt, I can destroy it. But here we have an issue in the law where you may well own something but not have the right to destroy it, mutilate it, distort it, modify it, or change it. And this, of course, is counterintuitive to much of our transactional practice. And so for those of you who are general transactional lawyers engaged in transactions, especially real estate transactions we'll look at closely soon, this is why it's very important to be aware of VARA and American moral rights laws. And so this brings us to the Visual Artists' Rights Act of 1990. And what we're going to look at, as you see on our slide here, is specifically what kinds of artists have moral rights, what kinds of works, creations, art counts as legitimate works to which these moral rights attach. The remedies are the same as our copyright remedies we saw, which have very powerful statutory remedies. And we're going to look at a famous case coming out of New York soon on that in terms of graffiti art. And we're going to look at the specific rights that are protected by VARA, and that's the right of integrity and attribution. Real quick on our slide here, we'll do a little sidebar into the legislative history of VARA. And this comes from House Report 514 from the 101st Congress in 1990. The right of integrity allows the artist to prevent any deforming or mutilating changes to his work, even after the title in the work has been transferred. The right of attribution allows the artist to be recognized by name as the creator of a work. If there exists the real possibility that the fruits of this effort will be destroyed after a mere 10 to 20 years, the incentive to excel is diminished and replaced with a purely profit motivation. VARA mitigates against this and protects our historical legacy. So you can see there are these ideas that this is a very significant alteration to our standard economic-based transaction system. And then here we have a quote from a law review article written by Justice Ginsburg's daughter, Professor Ginsburg. Moral rights afford protection for the author's personal, non-economic interest in receiving attribution for her work and in preserving the work in the form in which it was created, even after its sale or licensing. So let's talk on our next slide here with the question that we've posed, what kind of work? Well, it turns out only certain works of visual art receive these protections of rights of attribution and integrity against mutilation or destruction or modification. And so the basic general rule is that not all art is a work of visual art. And I use the acronym here, WOVA, we can call it WOVA for a work of visual art, just as a shorthand. But basically, not all art can be a WOVA, only certain categories. And so the US code, copyright code, defines what a work of visual art is, both positively and negatively. And so here we have the positive definition on this slide. It is a painting, drawing, print, or sculpture existing in a single copy. Let's just pause there. So already we can see it's a very narrow subset of all the different artistic creations that one can do. It's got to be a painting, a drawing, a print, or a sculpture existing in a single copy. So it doesn't include movies, doesn't include music, other types of things that copyright adheres in, obviously. Doesn't include books, paintings, drawings, prints, or sculptures in a single copy, or if it's a limited edition of 200 copies or fewer that are signed and numbered. So you can think of like a lithograph, right? You may make 200 copies of the same piece of art. You sign it and consecutively number it. Those 200, VARA attaches to those 200 also. Many of you may have bought a lithograph in a series of 200 or less, a painting lithograph, for example, that were consecutively numbered and signed by the author, and it turns out you better be careful with that piece of art because it's a work of visual art subject to VARA. Now let's look at what, on our next slide, a work of visual art is not, because the code is very unique in Title 17. It defines a work of visual art in terms of that positive enumeration that we just went through on the prior slide, and then it simply says, but a work of visual art does not include the following things. So even if it happens to be one of those things we just said, it doesn't count if it's one of these things. And so what can we say is unequivocally not a work of visual art, even if it otherwise may be, you know, for example, a painting or a drawing or a print or a sculpture, for example? Well, even if it's those things, it won't include any poster, map, globe, chart, technical drawing, diagram, model, applied art. I emphasize that because we're going to talk a lot about applied art shortly in terms of this line between work of visual art and applied art, motion picture, audiovisual work, book, magazine, newspaper, periodical, etc. Number two, merchandising or advertising promotional materials is the other example that we're going to look at too. Now, the statute doesn't define what is applied art, doesn't define what exactly is merchandising or advertising, so that's found definitions in case law that we will be looking at. But let's talk real quick about what are the two rights that we're talking about as we double click on this. The right of attribution. This comes from 17 U.S.C. 106, capital A, little a. And basically what it says is that the right of attribution and integrity, authors of works of visual art have the right to claim authorship of the work, to prevent the use of their name as the author of a work that they didn't create, and prevent the use of their name as an author of that work if it's distorted or mutilated, so that their name can no longer be associated with it in other ways. This is this concept of attribution and fair, proper attribution. Our next slide, we'll look real quick at the second right, because of course, VARA and moral rights, we're really talking about two rights: attribution, integrity. Integrity, the right to prevent any intentional distortion, mutilation, or other modification of the work that would be prejudicial to the artist's reputation. And if there is such an intentional act, then that's a violation. And secondly, the second aspect to the right of integrity is to prevent any destruction of a work of recognized stature, and any intentional or grossly negligent destruction is a violation. So here what we have is two different ways that you can violate the right of integrity. You can grossly negligently behave in a way that destroys a work of recognized stature, which is a particular kind of work of visual art, and then you can be liable. Or you can be liable if you intentionally distort, mutilate, or modify a work of visual art. Can moral rights be waived? I know all of you transactional lawyers are saying, but we're going to enter contracts, we're going to make the artist waive these rights. I don't want to deal with this. They can be, but it's a very limited waiver right. Rights may be waived only if the author expressly agrees to such a waiver in a written instrument signed by the author. And that instrument has to specifically identify the work, the uses of the work to which the waiver applies, and it only applies to that work and uses of the work that are identified. And so here's the key practice pointer for you. General boilerplate language on waivers is not going to work. For an artist to waive their moral rights, it has to meet these very specific requirements of the US Code. So let's do a quick summary of what we've talked about here with VARA before we start diving into the cases. Remember, it attaches to specific kinds of single sculptures, drawings, paintings, or prints, or sub 200 copies, like lithographs. This, of course, can include graffiti art. Graffiti art is paintings, drawings. What types of things are we talking about? Well, they're often going to be present in museums, or for you transactional lawyers, they're often in commercial real estate buildings, it turns out. A lot of the VARA cases involve commercial real estate buildings because some developer comes along, builds a beautiful, nice building. They want a nice piece of art in the lobby or out front. They go and hire an artist and they build this cool, sculpture or whatever the art may be. And it's a one-off sculpture, one-off drawing, painting, whatnot, in the building. And now it's in the building. And that author of that has specific VARA rights. And then the building may get sold down the road and someone says, yeah, I don't want it, I'm going to throw it out. Be careful. Now, if the art is applied art, advertising, or promotional art, it'll fall outside our definition of a work of visual art and won't have moral rights protection. And so the integrity right, of course, is just to make sure that we don't have these specific kinds of works being intentionally destroyed, mutilated, or modified, or grossly negligently damaged or destroyed if they're a further subset of works of visual art with recognized stature. We'll look at a case on that shortly. We've looked at the attribution right, and we have to remember that there's a limited waiver ability. It's a high bar, and you need to have the waiver done properly and correctly by copyright lawyers who know how to do this. And of course, if you trip these wires and violate them, there can be statutory damages of up to $150,000 for a willful violation. So our first case we're going to get into, we're asking the question, is it art or is it lawyer advertising? And so here we're looking at a case brought by a plaintiff by the name of Pelara. Pelara is an artist, and she has often been commissioned to make banners for private or corporate events. And she was commissioned one day to make a banner for a one-day event in Albany, New York. It's the annual legislative lobbying day. And so she goes out and makes this banner. It's erected in the Empire State Plaza on 10-foot metal poles. But it turns out the people holding this kind of legislative day, lobbying day type, we all get together and talk about what's going on in our legislative lobbying world. The people organizing this event didn't get a permit. And city officials came along and said, look, there's this huge banner up. It's on these 10-foot poles. There's no permit. So they took it down, and in the process of taking it down, they destroyed the banner. So Pelara, the artist, sues under VARA. Pelara says, look, that was my painting, drawing, creation. It was a one-off. And this was political advocacy material for the client that had hired her to make the banner. And it was a one-of-a-kind work of visual art. Now, the defendant claimed it was advertising and promotional material and outside VARA. So let's take a look on our next slide here at what we're dealing with. And there you see a picture of Ms. Pelara's banner. Preserve the right to counsel, now more than ever. And there's all those people there lined up. There's a lawyer, and they're holding signs, and they're all, it's artistic. There's all these different people, milling about, and it's sort of conveying a message in terms of the right to counsel, now more than ever. Executive budget threatens the right to counsel. And so it was some advocacy organization had hired her to make this banner and to deliver this message to sort of help with their legislative lobbying efforts. So, now you've seen the banner. Let's go to our next slide. We're going to see the case decision on what happened. And it's the case of Pelara versus Seymour, reported at 344 F3rd 265, and it's coming out of the Second Circuit in 2003. And here's what the Second Circuit held. Although the banner was very artistic and creative, It was created for the purpose of drawing attention to an information desk. It was part of a lobbying effort, and the banner overtly promotes in word and picture a lobbying message. The directions were given by the commissioning party in other words, the commissioning party directed Ms. Pallara on the promotional advertising purpose that the banner was supposed to have. And that becomes a significant fact that brought the banner outside of VARA, because it was the commissioning party that wanted this thing to be promoting a certain thing in a certain way, basically. And here's what the court said. While the commissioning party's name did not appear on the banner's planned installation adjacent to the information table and its explicit lobbying message leave no doubt as to the banner's purpose as promotional and advertising material for the lobbying effort. And so because it was created for advertising and promotion, it is not a work of visual art. And so there you have a good example of this line between work of visual art, advertising, promotion. And you saw the banner. It was actually a very nice piece of artistic, creative work. It was one-of-a-kind work, but because it was created for particular advertising promotional purposes, expressly by the party who commissioned it and requested it and wanted to deliver a certain message, the court said, we're not going to let that fall within VARA and give you this powerful remedy for its destruction. Ms. Pallara lost. This brings us to the next case, the case of the commercial building sculptures. So here we have a situation that for transactional lawyers and real estate lawyers who may be watching this program, you will see this situation regularly, where you have commercial buildings and you have, artistic sculptures that are inside the building. And so this case involves the following facts. Plaintiffs who ultimately filed the suit, and we'll follow the same model. I'm going to tell you the facts, I'm going to show you the art, I'm going to tell you what the case did. The plaintiffs were professional sculptors, and they were hired by this commercial building owner to build a complex permanent installation in the building. Primarily in the lobby of the building. And it was basically a large walk-through sculpture that had various elements constructed from recycled materials. And these elements were put together and they were fixed to the walls, the ceiling. There was a large mosaic made from recycled glass that was in the floor and the walls. There was even the portion of a school bus that was used in auto parts in this whole display. And there was a theme that the artists were creating with this sort of big sculpture that sort of went throughout the lobby. And the theme was built around environmental concerns and recycling. So in any event, they're building this thing and making it, and the owner of the building goes into bankruptcy. And the party who then acquires the building in a bankruptcy becomes the defendant in a VARA lawsuit. And basically, the defendant came along, got the building and said, I know you built a lot of this thing, quit building it, vacate the building, I don't want this thing in here. And so the artists immediately sued to stop the destruction of their artwork. They didn't want this thing destroyed, and to try to get an injunction denying the owners of the building the right to go and destroy this funky walk-through sculpture that they had made in the building. So let's take a look on our next slide. Here are some pictures of the sculpture as it was sort of being built in the building. And so there you can see on the left the elevator doors, and you see this kind of sculpture paneling that goes over the doors and it comes down to the floor. In the middle, you can see the same part of the picture, which is the floor and the wall in terms of this mosaic and sculpture, and then the lights, and and then you see on the right side even this use of auto parts and a school bus even kind of built into the wall and coming out. And so it's this very complex, creative, artistic sculpture in a building. So now let's go and see what happened. On our next slide, you see the case is Carter versus Helmsley Spear Incorporated. It's reported at 71 F 3rd 77, and it comes out of the Second Circuit in 1995. And so here's what happened when the artists sued to get their injunction. They go to the trial court, and the federal district court says, this whole sculpture is one work. So it's a single work. All these pieces, it grows, it lives, it twists, it turns, it changes, but it's all one work. And so the district court granted a permanent injunction saying to the new owners of the building, you can never distort, mutilate, modify, destroy, or remove that artwork. Now, the defendants had argued to the trial court that, hold on, a lot of this sculpture is applied art. There's buses, there's stuff that's utilitarian, there's ornamentation that was 2 or 3 dimensional that's really just fixed utilitarian objects and the like. And what the Second Circuit held is that even if it's true that some of the elements really were utilitarian, the sculpture as a whole could still be a work of visual art and would not be treated as applied art. And so this is important, this case, because what it shows is that a work of visual art can include portions of applied art. So you could have a series of what are applied functional type art, things that would otherwise not qualify, put together with other artistic things, and the whole could be a work of visual art. And so therefore, VARA's definition of a work of visual art attached to the sculpture. Now the case went south for the artist for another reason, but it's outside the scope of this program. But what's very, very important is the idea that a sculpture like that is a work of visual art and can be a work of visual art, which means absent a waiver being signed on the front end or at some point by that artist, you take that building with that. And if you don't like it and it's not to your taste, you may not want to buy that building lest you face a large lawsuit. This brings us to the case of the living garden. And so now we're going to talk about actual plants, living floral landscape gardens. And so here we have a plaintiff, well-known artist, nationally known artist, Kelly. Kelly is known for floral landscape paintings, but Kelly moved into live art at one point. And so what happened is this. The city of Chicago comes to Kelly and says, hey, look, we have a Chicago park. We want to create a really ambitious, cool, awesome new display of wildflowers, wildlife, that type of thing. We want to have a really great park on a mammoth scale. And so Kelly is commissioned, and Kelly goes and creates what we can call a living garden, living art. It was ultimately known as Wildflower Works. Many of you who live in Chicago have probably walked through this park when it was around, and so you know what it looked like. And you're going to see pictures in a second if you don't. But anyway, here's a description. It's 2 elliptical flower beds, each as big as a football field. And each were filled with a variety of native wildflowers. These oval elliptical kind of shapes were edged with steel borders. It was promoted as being living art, but that was in the 80s and 90s. By 2004, the garden had fully deteriorated. And it was then modified by the city to really meet new goals of the city for the use of that area, right? And so the oval flower beds were reconfigured into rectangles, other things were changed and destroyed, and there was just a different use that was going to be put to this space for the city of Chicago. Well, Kelly wasn't happy, so Kelly sued. And Kelly said, look, the living garden is a work of visual art. It's a painting and a sculpture. And even though normally we conceptualize and cognize the idea that paintings and sculptures are done in the medium of acrylic or paint or pencil or whatever on a canvas or a piece of clay being sculptured, here the medium was living material. Flowers with the framing, the shape and all that. And so it was living art. Let's take a look at our living art. Here you see some pictures of the Kelly creation known as Wildflower Works. And we've got 4 pictures you can see. If we take a look at the first picture on the top left, that's sort of an overhead view from pretty far away. And you can see the 2 oval football field shapes that were created by Kelly with the bordering. And if you look in the middle or beneath it, you can kind of see a better sense of that framing, bordering of it, the unique rectangles that sort of bounce in the middle of it. And if you look at the lower left and then the far right picture, you get sort of a more granular view of the garden and the wildflowers. And really it's just a beautiful installation if you like flowers. And it's very artistic, creative looking, obviously. So what happened to the city of Chicago? On our next slide, you see this case also went up to the 7th Circuit. The case site is Kelly versus Chicago Park District. It's reported at 635 F3rd 970 from the 7th Circuit in 2011. And the district court held the following. Wildflower Works could be both a painting and a sculpture, and therefore it was a work of visual art under VARA. But the district court held, even though living gardens could be a work of visual art as living paintings, living sculptures, it lacked sufficient originality to be copyrightable. That's what the district court held. The district court basically said, yes, it's a work of visual art, but it's so not original that it couldn't even get a copyright if you wanted. Now remember, for copyright law, the bar to originality is very, 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 very low. Like literally, if you're doodling right now because you're listening to this board, you've got a copyright in that doodle. So it's not a big bar to get to get a copyright. But the district court here has held that it lacked originality. But critically for VARA, it did say that this is a work of visual art. Goes up to the Seventh Circuit. What does the Seventh Circuit do? The Seventh Circuit confronted the following procedural complexity. The city didn't appeal the finding that it was a painting and a sculpture. And so that issue was not before the Seventh Circuit. Now, the Seventh Circuit said, quote, "This is an astonishing omission," end quote. So the Seventh Circuit was clearly very frustrated by the fact that the city didn't even challenge the finding that a garden could be a painting or sculpture and therefore a work of visual art under VARA. And because it wasn't before the court, it couldn't do anything and address it. But it did make a point of saying this is an astonishing omission by the city. And it then talked about real questions about the validity of that holding in terms of the impropriety of treating a living garden as a work of visual art. But the court proceeded to affirm the district court's holding, not on originality grounds. The court simply said, look, you can't get copyright protection in a garden because it's not permanently fixed, because the plants live and die. And copyright requires not just you create something original, but it be permanently fixed in some form, right? The pen touches the paper, the words get typed into the RAM on the computer, into the code, the clay gets molded and the like, and that's permanently fixed. Plants aren't permanently fixed. They may be there temporarily, but then they die and they disappear. So therefore, the court addressed the case that way. So Kelly lost, but what we do confront is a district court that said a painting and sculpture could be made of living material. And the Seventh Circuit, though, saying, no, I don't think that ever really would be a work of visual art, so it remains a slight open question in the law. It may get ducked consistently because of this permanent fixation for plants and originality, perhaps. But remember, this was a wildflower garden that, the plants come and go. That's not necessarily true for many plants that may sort of, be quite permanent within copyright law. You can have trees that live hundreds of years. There's no reason to think that would necessarily not be deemed a permanent fixation. So at least for those of you watching, living gardens themselves could potentially have VARA protection. We'll wait to find out. This brings us to the 5 Points graffiti art case. Now this is a very, very famous case. It got a lot of press attention coming out of New York. And so this case requires us to get to the bottom of the following facts. We have graffiti artists who had painted for some time at a series of these dilapidated warehouse buildings in New York. And it ultimately became a space that artists came to and did their aerosol or graffiti art. And quite literally, they would rent space in these dilapidated buildings and then come out and paint and create this really cool looking graffiti art. And often the art would be painted over by new art. That was actually part of almost the sort of the ethos of the artistic creation of the space. And this had gone on for many years. And so you had these sort of dilapidated warehouse buildings that were adorned in all this crazy cool aerosol graffiti art. But some new owners came along and bought the buildings. And the new owners wanted to demolish the art and get rid of the buildings. Plaintiff artists were not happy. So the plaintiff artists filed suit. And they filed a lawsuit to stop the demolition. And so they filed their lawsuit under VARA, saying these are original works of visual art. There are paintings, drawings. You can't demolish them or destroy them. We have rights under VARA. And so we want a permanent or preliminary injunction is what they went and asked for originally. Now the trial court denied the preliminary injunction. And the moment the preliminary injunction was denied, like literally that day, the owner apparently destroyed the art, just whitewashed it all, and took no steps to let the artists come in and save that art. Now later on, this will be called, quote, an act of pure piqué and revenge towards the artists who had dared sue. Nonetheless, the plaintiffs didn't get the injunction, but they said, you've now destroyed our art. It may be true that we didn't get an injunction, but we're going to go to trial on our VARA claim. And part of the reason they didn't get the injunction was the trial court said, look, the art's temporary, transitory, you paint over it anyway, so you don't need a preliminary injunction. Monetary damages will suffice. That's what the trial court said. When a trial court says, it's fine, money damages will be okay, you may want to be careful before you take further acts, but here they just literally destroyed it the next day. So the plaintiff's artists said, we'll go to trial. And they chugged along in the case, and they eventually went to trial, claiming that their art was of recognized stature and was a work of visual art and was entitled to protection. Let's take a look at the art. Here's a photograph of 5 Points, the building, the warehouses that were known as the 5 Points area. And there you see all these really cool sort of, I personally think they're cool, but they're logos and artistic characters and creators, and it's just sort of this aerosol graffiti art all over the place. And it's sort of, they're all merged together, and they're in different corners and sections, and there's different, creations everywhere, artistically. The case on our next slide is the case known as Castillo versus G&M Realty Limited Partners. It's at 950 F 3rd 155. Went up to the Second Circuit in 2020, and here's what happened when the Second Circuit got its hands on this case. It held that the works were indeed of recognized stature, and even if the artwork was regularly to be painted over, that was sort of the way that place operated, it still would have VARA protection. In other words, if a piece of art goes up, even if one day it may get painted over, at that point in time, you don't get to just come and destroy it. Other people may be allowed to paint over it because of the structure of the organization that they created in terms of the rights to destroy art, but other people can't come along and just tear it down, right? And so that has VARA protection at that point in time. And what the district court did was award statutory damages at a maximum level of $150,000 per piece of art, per work of visual art. And so basically, the total verdict was $6,750,000 because there were dozens of works, each of which the district court hit the defendant with at $150,000. So if we go back to that picture, and let's go back to the slide again and take a look again at the picture of 5 Points. We're talking about, $150,000 per work of visual art. And so if you look at the sort of that green helicopter thing above this 5 Points on the right side, the little green helicopter, 150 grand. The picture in the lower right corner, 150 grand, et cetera, over all this building complex until you get to $6,750,000. So when the trial court said, I'm denying the preliminary injunction because money damages can suffice, it really meant it. Because it gave some real money damages. And part of the reason it hit the defendant so hard was this idea of this nastiness of just destroying the art the moment the preliminary injunction was denied, instead of coming up with some mechanism to let the artists save their art somehow. And so that became a boomerang. And a great practice pointer here is don't confuse winning a preliminary injunction remotely with winning on the merits eventually. Be very, very careful, right? But it's a good example of what do you do when you acquire a commercial building that has got graffiti art on it? And how did that graffiti art get on the building? And what does it mean if you go destroy it? These are serious questions for real estate transaction lawyers to be thinking about within the confines of the VARA statute. This brings us to the Burning Man bus case. I'm sure many of you go to Burning Man. I've never been. I hear it's pretty cool. This case involves a bus known as La Contessa. Now, La Contessa was basically a replica of a 16th century Spanish galleon. And this was used at the Burning Man Festival out in the desert of Nevada where Burning Man happens, this sort of multi-day party festival thing. And so basically, the plaintiffs got an old school bus and they built this galleon sort of facade over the school bus. And it had decking and handcrafted like figureheads on the front of it. It looked like a Spanish galleon. It's really cool. It's taken to the Nevada desert and it was used at Burning Man, the Burning Man Festival, to move people around, basically, because it was like built on a school bus and it was a bus that moved people around. It was just a really cool looking bus, right? Later on, the bus got stored at the defendant's property. And after some time of sitting there, the defendant burned the bus, the wooden structure, so that the scrap metal dealer could come and take the underlying school bus. Now that wooden structure, that original, sculpture, right, that was created, sat on top of the bus, The creators said it was a work of visual art under VARA. You destroyed La Contessa, how dare you, and we're suing you. So let's take a look at La Contessa. There it is. I have to say, that's pretty impressive. You know, and you can see there on the picture on the right, you can see the school bus sitting beneath our Spanish galleon. And you can see on the picture on the left, you've got this kind of very artistic sculpture, creative sort of this, you know, the way boats sometimes have these sculptures coming off the front, you know, leading the way through the ocean and whatnot. And here, leading the way through the Burning Man partygoers. But in any event, that is our La Contessa that was used as a bus to shuttle people around. And so the case makes its way up to the Ninth Circuit. It's the case of Cheffins versus Stewart. It's reported at 825 F. 3rd 588, Ninth Circuit, 2016. And so the question, of course, was alluded to at the beginning of this program. Is that a work of visual art or is it applied art? Where is this line between a work of visual art and applied art? What the Ninth Circuit ruled is that an object is applied art as opposed to a work of visual art where the object initially serves a utilitarian function and it continues to serve such a function after the artist makes his or her embellishments to it. That's page 594. So let's pause there and just double click on that really quick for you. This was a bus, and the artist embellished the bus by building this cool sculpture around it. But even after that cool art was made, it continued to function as a bus. It shuttled people around the party. And the result is that makes it applied art, not a work of visual art. That was page 594. Now let's look at footnote 7 in this opinion, because footnote 7 in the Ninth Circuit opinion is a very important footnote. And the footnote, it's trying to illuminate this idea of, you know, it initially serves a utilitarian function, it continues to serve a function. But, you know, this is a spectrum, right? This is not like a light switch. You know, maybe there it was a bit of a light switch. Yeah, it was utilitarian, but I mean, that's not always the case. And so the court tried to unpackage this a little bit. And in footnote 7, which has been an important footnote in subsequent litigation, it said the focus is on objects that, in fact, continue to serve real utilitarian functions, as opposed to those which may retain the ability to serve utilitarian functions in theory. And basically what this is getting at in footnote 7 is the idea that, look, we really want to focus on objects that, at root fundamentally, even once they've been adorned with art, they really do fundamentally serve some utilitarian function or master, right? That's what they're doing. In distinction to objects that are utilitarian in nature, they get embellished or adorned with art, and at that point, they theoretically could still serve the original utilitarian focus, but that's not really what they're doing, right? So here's an example. Just we can pause there and I'll give you an example. Imagine a door, like a cool door, a nice old wooden door, and an artist does a beautiful painting on it. Now, the door served a utilitarian function. I mean, it was a door. And the art is put on it, and someone buys the door as a nice piece of art. Now, it's still a door. It's got hinges. You can hang it on a wall. You can use it as a door. Is it a work of visual art, or is it a utilitarian door? If you hang it on the wall like a painting, does that make it a work of visual art, even though it could still be used as a door at any time? If you actually use it as a door, is it not a work of visual art such that it's only a door? That's the question. Another one that comes up often when we as copyright lawyers and talking about VARA debate and discuss these issues is the issue of, for example, the famed Monet napkin. Monet was apparently once at a restaurant, and he doodled on a napkin, gave it to someone. You're a very lucky dinner guest of Monet when he doodles on a napkin and gives it to you. Now, that napkin, it's a utilitarian napkin, right? It's used to wipe your mouth, you know, after you've eaten your meal. It can still be used in that fashion after Monet adorned his little doodle on it. Is it a work of visual art? A one-of-a-kind Monet drawing? Or is it a utilitarian applied art napkin? That's the question that this rule is getting at. And so you can see the fault line that comes from Cheffins here is a difficult fault line to straddle, depending upon the facts of what could be happening. Now here, applying that rule was somewhat easy in the Cheffins case, arguably, right? Because what the Cheffins court held, applying this rule they had constructed, is that here, the bus continued to serve the utilitarian function of transportation even after the artistic embellishment and the adorning of art to the bus. And because it was used as a bus to move people around the desert event, it therefore was only applied art. So the artists were unable to get their VARA statutory damages of 150 grand for the bus. And that was the end of La Contessa. I don't know if in subsequent years someone else has built a La Contessa 2 at Burning Man. If any of you attend, let me know. This brings us to the case of the LA Chinese American Museum public art case. This case involves plaintiff, who was an artist of internationally known repute, and he was a muralist, and he's known as Sharktooth, and he created shark-based images. Let me just disclaimer here, this is a case I litigated, I represented him, so I know all about this case. In any event, the Los Angeles Chinese American Museum had a multi-month exhibit. They asked Sharktooth and many other Asian American artists to participate. He had showcased at the museum before, and so for this event, he created 88 original pieces of artwork to be hung in the courtyard of the Chinese American Museum. And they were, he named his whole exhibit Year of the Shark Red Packet. And basically it was 88 red tote bags that were silk screen painted with a shark image with some hand embellishment done on it. And then on the back side was some Chinese silk screened lettering in gold that was done. And then they were hung specifically in the courtyard of the museum on rope and clips, and the whole point of the artist's creation was to evoke the idea of his Chinese American heritage and the laundry trade, and that was sort of the spirit of this art. And so at the end of the event, the hanging art was thrown away by city trash crews. And so plaintiff filed this VARA lawsuit for the destruction of his 88 individual artworks. And let's find out what happened. Here's a picture. So you see on the right, there's a picture of this red tote bag. And you can see where the case is going and where the issue is going, because a bag is a utilitarian object, right? And these red tote bags then were silk screened with the art on the front side of the shark and the back side the Chinese lettering. And then they were hung in a particular way across the courtyard. And you see just there a picture on the left of the hanging artwork in the courtyard that hung for the duration of this whole art exhibit that was being held at the Chinese American Museum in downtown Los Angeles. So this case is reported at Liu versus City of Los Angeles. It was case number 20-10948-DDP before Judge Pragerson, Central District of California. And we have a couple decisions here that will explain what the court said. One is reported at 2022 Westlaw 60592, January 6, 2022, and one at September 13th, 2023. And so basically, here's what the district court held. There was one work of visual art comprising the entire group of the 88 hanging tote bags. In other words, the entire exhibit, as you saw in the picture on the left, where they were all hanging together, that was a work of visual art. The bags individually were utilitarian applied art if they were to be solo bags. And so basically what the court said is that the one work as an art exhibit was not utilitarian, was not applied art. It was a work of visual art when hanging. And so when it was destroyed, that one work of visual art was destroyed. But the court also held that the tote bags alone were applied art and utilitarian. And the court cited to Cheffins, the La Contessa Burning Man case, and basically said that after the bags were to come down at the end of the exhibit, because they were to be sold to individuals who wanted to buy them, the court concluded that they were to be sold as tote bags and so functioned as utilitarian objects as opposed to works of visual art. And so the entirety was a work of visual art, but the 88 individual bags were not individual works of visual art. And so this is the outcome of the holding of that case, Liu versus the City of Los Angeles. And the query then we're left with is, what do you do with a painting on a door? Monet's drawing on a napkin. The medium matters is the lesson here that's very important, and it can very much affect the analysis. For example, what if in that case the bags had the handles cut off so that they couldn't be held as bags? Would that make them not totes anymore, such that they were more just like a traditional piece of canvas? We don't know the answer to these questions, but these are the questions the VARA cases push at on that really critical line coming from Cheffins in footnote 7 in terms of what is it functioning more as versus less than once this utilitarian object is adorned with art. Because after all art is on utilitarian objects. Even the canvas, that traditional canvas that artists paint on, is a piece of canvas. It can be used in myriad utilitarian ways. Now this brings us to Catherine the Great mural. Here we have the case where Audrey Flack's an artist. She was commissioned to create a statue of Queen Catherine of Braganza, and that's the namesake of the borough of Queens in New York City. And so she comes along, she starts making this sculpture of Catherine the Great, but ends up suing Friends of Queen Catherine Incorporated, the nonprofit organization that was managing the sculptural project. Basically what happened is Audrey Flack's sculpture of Catherine the Great was left outside and was damaged. And rather than coming and paying Audrey Flack to resculpt the face and fix it, the nonprofit got one of its assistants to do the work. Now, the district court gets this case, and, well, first of all, before we go to the district court, let's take a look at the picture of this sculpture of Catherine the Great of Braganza. There we have it. So that's a picture, that's Audrey Flack, the original artist sculptor, creating this. It's a pretty incredible sculpture, as you can see there in that photograph of the sculpture. And that gives you a sense of what this work of visual art was in terms of this sculpture, this one-of-a-kind sculpture. So let's look at what happened now. And this is Flack versus Friends of Queen Catherine. It's reported at 139 F sub 2nd, 526. Comes out of the Southern District of New York in 2001. The district court held that the plaintiff's claims of the partial destruction were valid because it's a sculpture existing in a single copy within the definition of a work of visual art. But as to the plaintiff's claim that you allowed this thing to sit outside, the elements damaged it because you were negligent, the court said that's not a violation because it was not damaged and was easily repairable as a result of whatever weathering had happened. Now, what the district court also held, though, was that as to the artist's claim that you went out and hired an assistant to resculpt the face, and that act of hiring someone to resculpt my sculpture, you distorted and mutilated it. Remember the language? The right of integrity protects a VARA artist on a work of visual art from having their work distorted or mutilated or destroyed. Here it was a claim of distortion or mutilation of the sculpture. And there the district court said, yes, that is a valid claim because the assistant was potentially grossly negligent. She wasn't trained in conservation, wasn't competent to perform the work without supervision. And the argument that, well, we have to do something to conserve it is not enough to allow you to go and distort or mutilate a work. And so the question ultimately that would then be left in that case is, was it a grossly negligent distortion or mutilation? There's an example of where you need to be very, very, very careful when you're dealing with public art or outdoor art that may have been damaged by weather or maybe isn't finished, and you go and hire someone other than the original artist to finish it. Again, it's a great example of how that nonprofit should have gone back to the original artist and figured out some mechanism with the artist, or the nonprofit should have got the waiver on the front end. This brings us to the backyard art case. Here we have the case where plaintiff was a well-known professional artist and sculptor, and the defendants were people who owned a home in New York, and they had hired the plaintiff to create a backyard sculpture. It was fabricated out of steel. It was about 40 feet long. It weighed 6,000 pounds, and it was a big white painted swan that they stuck in their backyard. And basically what happened is the defendants had this in their backyard for years. It was not viewable by the public or by anyone else. It was just sitting in their backyard. They just loved this 40-foot long swan, 6,000 pound sculpture. And the defendants came along and sold the property to a new purchaser. And at that time, the defendants took the sculpture from the property before the close of the transaction. And so the plaintiff artist then sued under VARA. And the plaintiff claimed that, look, that was an intentional or grossly negligent modification and destruction of a work of recognized stature by me as a famous artist. And it was very important to have that work there because there was another sculpture like half a mile away or something that it kind of, the swan went with the other one and it all went together in this kind of theme the artist believed. Now, what the court held, let's take a look real quick at, before we get to the holding, let's take a look at the picture of the art. There you can see this kind of sculptural swan sculpture in the backyard. And there you have it. It's a black and white photo, but that's the best photo I could find for you to contextualize what this is and whether it's a work of visual art. So it's a sculpture, all right. But let's go to the case and what the case held. This is Scott v. Dixon, and this is getting at a work of recognized stature. It's reported at 309 F sub 2nd 395. It comes out of the Eastern District of New York in 2004. Here's what the court held. Just because the plaintiff's a known famous artist, it doesn't mean that every single work created by her is one of recognized stature. In other words, Monet can create something that may not be a work of recognized stature. It depends. This was not a sculpture of recognized stature because fundamentally it was in the private backyard of the home. It was never seen by the public. And so even if it had artistic merit, it wasn't the type of art that could qualify to be one of recognized stature within an artistic community. Now that's how the court dealt with that case, but it still leaves open the question that we leave for you here. What if Monet does doodle on a napkin and gives it to you and you never display it or show it to anyone? Is it really the case that that is not a work of visual art? I think it is a work of visual art. But we'll wait to see. If any of you have Monet's napkin, please don't destroy it. But if you do, maybe the heirs of Monet can litigate it. Not likely. But let's now shift to illegal murals. This is going to let us look at the case of English versus East 11th Street LLC. This is a 1997 case from the Southern District of New York. You have the site there, and the question we get at here, and there you see some murals that come out of that case. And these murals were done on a building without permission. They're illegal murals, right? So here's the question. Two questions, copyright question and a VARA question. You got a bunch of artists who paint these murals on a building, and they don't have permission. The artists then go in for a preliminary injunction, and the developers seek summary judgment when they have a fight about the ability to destroy these murals by the property owner. And the court held that the murals were placed illegally on the property, and therefore they are not entitled to protection under VARA against destruction. And what the court basically said is that if you paint illegally on a building, your moral rights can't attach to that. And here's why. Quote, otherwise, parties could effectively freeze development of vacant lots by placing artwork there without permission. Such a construction of the statute would be constitutionally troubling, would defy rationality, and cannot be what Congress intended in passing VARA, end quote. That seems very logical and correct, frankly. But here's a question, but it's an unsettled question under VARA law for sure. But here's another question that this gets at. Okay, that may be true that the artist can't stop the destruction of that mural by the property owner since the artist put it there illegally. Of course, how long ago was it put there and how long did it stay? What if it stayed for 7, 8, 10 years? Does adverse possession type concepts attach such that now moral rights spring into that art? Those are why these questions are hard and are not fully answered by the holding of our Southern District of New York court there. But the other aspect to this is from a copyright perspective. Can a third party come along and take the image and commercialize it? In other words, you see the image there, that kind of heart logo with the crossed hands in it, it's really cute and all that. Could a t-shirt company come along and say, oh, that's a really cool looking piece of art. I'm gonna put that on t-shirts and start selling it. And if the t-shirt company did, could the artist sue the t-shirt company for copyright infringement? In other words, even if VARA's moral rights don't attach, doesn't the artist still have a copyright in that such that the artist could license it and could stop someone from reproducing copies and creating derivative versions of that image? Just because you draw something illegally on a wall doesn't mean that you don't have a copyright in it. Copyright, of course, is distinct from the physical medium always. I mean, the copyright doesn't depend on it being on that wall, it's the image itself. And so there have been several cases, it turns out, where this type of thing has happened, where graffiti art has been taken and used by apparel type companies. It's led to litigation, and the litigation has resulted in settlements, so we don't have definitive answers under the law. The best advice you can give your clients if they want to take graffiti art they see out there and use it to create images on clothes and whatnot is they are probably infringing someone's copyright and they should be careful. So let's come to our final slide, our conclusions. I got a few pictures there for you again to remind you of some of the fascinating, cool art we've looked at as we've walked through this hour on moral rights in US law. VARA is a powerful addition of moral rights to American law for artists of certain kinds of very limited types of works. And that right of attribution integrity is very powerful. Violating it can lead to very large statutory damages awards that we saw. And I think fundamentally what's important for all of you, especially transactional lawyers who deal in transactions, to keep in mind is that this very concept of this right post-sale, post-transfer, you create a piece of art, you sell it to someone. The idea that the owner of that object now may be still completely limited by federal law and what they can do with it is counterintuitive to our thinking. We can burn our blenders after all, right? As we talked about earlier. So the point is, be very, very careful in all real estate transactions with embedded art or sculptures. If you're going to be asking to have a cool sculpture created for one of your clients, get VARA waivers on the front end. I've had many transactional lawyers reach out to me over the years asking for help in that front to make sure that when they get some cool sculpture created or made, they're not required to stick with it forever in case things change down the road. And remember, if you're in litigation as an intellectual property lawyer in this realm, the definition of a work of visual art is very complex. Applied art standard is not always clear as to what is utilitarian, and this line between utilitarian applied art and work of visual art is itself subject to continuing, and as you can see, constant litigation. And remember, although these rights are waivable, you gotta meet very specific federal standards to be valid. So in drafting waivers, be careful or speak to a copyright lawyer. And as always, if you have any questions, please feel free to email me, and I look forward to talking to you. Thank you.